A premises liability claim is also known as a slip and fall case. My guest is North Carolina personal injury attorney Michael A. DeMayo of the law offices of Michael A. DeMayo, and he's going to talk with us about the legal aspects often associated with slip and fall injuries. So Michael, thanks for being here today.
Thank you, Cindy.
Well, Michael, in your experience of dealing with slip and fall cases, what are the biggest challenges in establishing fault, i.e. who is at blame and therefore liable?
Well, the biggest problem in the state of North Carolina is that if the person who has slipped and fallen is even 1% responsible for their fall, they get nothing. Their recovery is zero, as opposed to other states, for example, like South Carolina, that have comparative negligence, that it's reduced by their percentage of negligence as long as they're 50% or less negligent on a slip and fall. So, for example, if there's an open and obvious hole in a situation and someone comes along and trips and falls, well, generally they're going to be held responsible at least 1% because they should have kept a proper lookout and looked in front of them and seen that there was a hole and avoided that hazard. In North Carolina, again, contributory negligence is a extremely significant hurdle to get over on slip and falls because they have to prove number one, if it's a proprietor, for example, that they knew or should have known that a dangerous or hazardous condition existed, and then secondly, that they either didn't take steps to remedy the situation and or warn of the dangerous situation. But if, for example, a grocery store, there's a spill and it happens and 10 minutes later someone comes along and falls, well, that may not be enough time to give the owner of the store notice that there was a dangerous or hazardous condition, and therefore there may not be liability. In addition, if it's not a clear liquid, if the person could have seen the spill as they were approaching it, then they're generally going to be deemed contributory negligent.
Wow. Now, are there differences in handling these cases if a person falls on a public sidewalk rather than private property?
Certainly. Generally, if someone falls on private property, homeowners, as a general rule, would be the responsible insurance carrier if indeed there's liability found. On commercial property, there is a heightened standard for an invitee, so the standard is different and the liability is different based on your status. There is a more significant duty if you are coming on the premises of a commercial property because they know that their premises are going to be used for that purpose and they are inviting people to come onto the premises as opposed to a private property.
Okay. Michael, what damages can a person recover for in a premises liability claim?
Well, same damage as you would on a general personal injury: lost wages, pain and suffering, and your medical bills. I mean, obviously if there's any future loss of earnings or any future medical needs or surgeries, those are all relevant in a slip and fall. But again, the problem is getting past that liability hurdle because of that standard. Because again, you know, if the defect is something that you could have seen if you were looking at the ground in front of you, then generally you're going to be found at least 1%, which is an absolute bar to recovery.
Okay. And if someone wants to reach your office, how can they do that?
They can reach us 3 different ways, Cindy. They can call us toll-free anywhere in the United States at 1-877-333-1000. They can go to our web, which has a number of different options, which is DeMayoLaw.com. And finally, they can text us by texting the word DeMayo to 333-100, and they will be given several different options how to get in touch with our office.
Very good. Michael, thank you for your time today.
Thank you, Cindy.
This is Cindy Speaker for Main Street Law.